Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the apex court jurisdiction on section 101 of BNS Act 2023. Corresponding law is 300 of IPC. Appeal filed on behalf of accused under section 415 of BNS Act 2023. Corresponding law section is 374 of CRPC against the judgment passed by the Honorable Sessions Judge accused punished under section 302 of IPC, etc. Appellant accused person has been convicted and sentenced to undergo imprisonment for life, etc. Apex Court delivered judgment in this case against appeal filed by accused. Accused prayed to the Honorable Court to set aside the Session Court order. The judgment reads follows.
The judgment reads as under follows. Since the High Court was dealing with the appeal in exercise of its appellate jurisdiction against conviction and sentence of the imprisonment, it was required to consider and discuss the evidence and deal with the arguments raised at the bar, let alone discussion of the evidence. This court do not find that the Honorable Court even cared to notice the evidence led in the case.
Next, appellate court has the duty to itself appreciate the evidence on the record, and if two views are possible on appraisal of the evidence, the benefit of reasonable doubt has to be given to an accused. The powers of an appellate court, which dealing with an appeal against acquittal and an appeal against conviction, are equally wide, but the considerations which weigh with it while dealing with an appeal against an order of acquittal and in an appeal against conviction are distinct and separate. The presumption of innocence of accused, which gets strengthened on his acquittal, is not available on his conviction. An appellate court may give every reasonable weight to the conclusions arrived at by the trial court, but it must be remembered that an appellate court is duty bound in the same way as a trial court to test the evidence extrinsically as well as intrinsically, and to consider as thoroughly as the trial court all the circumstances available on the record so as to arrive to an independent finding regarding guilt or innocence of the convicted.
In this case, testimony of I.O., which could not be completed, even his cross in chief, remained incomplete. But the question is whether his deposition fulfills the requirements of Section 142 of BSA Act 2023. Corresponding law section is 137 of Indian Evidence Act, and also I.O., which was never subjected to cross-examination. Section 143 of BSA Act 2023. Corresponding law section is 138 of Indian Evidence Act, embodies a principle of natural justice that evidence not tested on cross-examination is no evidence. Once again, a principle of natural justice that evidence not tested on cross-examination is no evidence.
Hence, in the eye of law, no deposition of I.O. cannot be taken into consideration to hold the appellant accused person guilty of the charge framed against him. Prosecution could not adduce any admissible evidence against the appellant accused person to prove charges framed against him. Prosecution has failed to discharge its burden. Finding of guilt recorded by the learned trial judge is legally incorrect and perverse. Hence, appeal is allowed. Accused appellant is acquitted from the charges framed against him.
Instead of relying on the information provided by this video, every advocate and law student should resolve their personal case. This video is purely theory. The Honorable Court decides each case on merits. Thank
Thank
you.
you.